Hi, everybody. Just letting folks in from the waiting room. Give us a couple of moments while we get set up here. Okay, welcome everyone to our webinar. The webinar today is about prenuptial, postnuptial, and cohabitation agreements in Washington State, what you need to know. I'll be joined here in a moment by Michelle Dellino. I just want to take a quick moment to introduce myself, and then I'll turn it over to Michelle to get started and introduce herself. My name is Melissa Rosenberg, and I'm here today as the facilitator for this webinar. I'll be taking questions and pitching them to Michelle as they come up. She's going to be delivering a lot of information on our topic, but if there are questions that you have that are not overly specific to your case, because we can't really get into the weeds there, but if there are more general questions that you have, please do pitch them to me in the chat, and I will present them to Michelle and see if we can get them answered. So I'm here to facilitate the webinar today. I'm also a therapist, so that's what I do. And one of my main specialty areas is working with clients who are dealing with various different stages of the divorce and separation process. So I do support clients who are in the early stages trying to determine if they're going to be able to, repair the relationship or if divorce is their healthier option. I work with clients who are amid family law challenges and cases and sorting through the emotions that are coming up for them there. And I work with clients who are post-divorce and navigating their new chapter. I'm also a couples counselor, and so today I'm here to help moderate the webinar. But if anyone is interested or has questions about counseling support, I can answer those as well. All right, so here we are today, and I'm going to turn it over to Michelle. One other thing, this is a Zoom format, so, bear with us on any sort of tech glitches that could come up, but we've got it pretty dialed in, so I think we'll be okay. All right, turn it over to Michelle.
Great. Hi, thanks for being here. I'm Michelle Dellino. I am the owner and founding attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we help clients literally all over Washington State. So if you have a problem, we probably have a solution, or we can help you figure out where to go to find that. So here's what you need to know about today. I'm going to be talking about prenups, postnups, cohabitation agreements, what that means for you when you might want to consider using something like that. And you can sort of go from there. But here's what you need to know. I'm an attorney, but I'm not your attorney. So nothing that I say today is meant to be legal advice about your specific situation. It's really just information and for informational purposes only. So you shouldn't rely on it. And like Melissa said, if you're asking questions like a really specific hypothetical, I'm not going to be able to get into that because I don't have all the facts and there's no confidentiality here or anything like that. But I can give you basic information, and I'm here today hoping that you're going to leave with more information that you came with, and that's going to be a really good thing. So what I'm going to do is I'm going to start just a little bit talking about kind of why we're talking about this. Like, why are we even here? So we're here because in modern family law, relationship contracts are becoming increasingly important and an increasing part of family law. So you should probably know what types of contracts are there, when are they used, what do they mean, do they protect me, do they hurt me, all kinds of stuff like that. So we're here to talk about that because these things are coming up more than ever. And they are, in my opinion, a very good thing to have and to do to protect yourself and to clearly define the rights and liabilities of people. So you don't end up in a divorce setting spending a whole lot of money on uncertainty. But before we do that, I'm going to tell you the basic types of agreements, and I'm going to tell you generally what it takes to have an agreement be valid, because a lot of people think, all right, hey, I want to have an agreement, I can go online and download something and that's going to make it valid. So that is not necessarily true. You really need to know that an agreement is only helpful to you if it actually is enforceable when you need to enforce it. So I've seen many instances where things that are literally just downloaded online are not going to be helpful and not going to be valid. So anyway, 3 types of agreements that we're going to talk about. 1 are prenuptial agreements, 2 are postnuptial agreements, and 3 are cohabitation agreements. There's different variations of postnuptial agreements. They can also be known as separation contracts. So that's something important for you to know. But anyway, prenups, as most people know, that's the most common agreement. There used to be a lot of stigma surrounding prenups. Oh, prenup's bad, or if someone wants a prenup, it means they're planning on getting divorced, or any number of things. And actually, none of that's true. Smart people get prenups, and prenups are not about what you have when you necessarily enter into a marriage. They're about what's going to happen and how your finances are going to be handled and treated. And what I mean by that, and the most important thing for you to understand about that, is that if you don't have an agreement and you get divorced, there's laws in Washington that are going to determine how your property is divided and the range of risk on that. If you want to have control over what that might look like, then you want to have an agreement. A really common example, and when I talk about how money is going to be treated during your marriage, are wages. If you're married and you go to work and you collect a paycheck and you put it in your own account, even though you went to work and you collected that paycheck and you put it in your own account, it's community property. Wages are community money because they're earned during a marriage. If you want wages to be treated as separate, so my money's mine, your money's yours, that kind of a thing, you need an agreement because that's not the law. So that's just a very basic example of why somebody might want an agreement. And then when you get divorced, if you want it to be, I keep my retirement, you keep yours, or whatever, I'm talking very high level here, you want an agreement so you're not fighting about things that you thought were clear. So anyway, prenups, the purpose of them really is to protect your assets, clarify financial rights, and to deal with spousal maintenance, whether that's going to be an issue, and to preserve separate property. So first, before we really get into it, I should tell you the difference between separate and community property. Community property is anything, let's just say for sake of the discussion, that starts when you get married and it ends when you separate. Not necessarily when you get final divorce papers, but when you separate. Everything in there is community. It's from the community period is what I would call it. There are instances in Washington where community-like property could attach before you get married if you're in a committed intimate relationship. And that's another thing that we'll get to later when we talk about cohabitation agreements. But anyway, you have a community period. Think of it as like a circle, starting, ending. Everything that you get during that time, whether it's income, property, even debts, every asset or liability is presumed to be community property that's earned during that time. And what does community mean? It means both parties have an interest. What that interest is going to be, I can't tell you for sure, but we can talk about that a little bit as well. Separate property, the other kind of property, are things that you acquired, assets that you acquired before marriage or after separation. Okay. Now, during the marriage, there are certain types of things that are still separate property. One would be an inheritance. If you inherit money and you keep it separate by operation of law, it's separate property. So that's a good thing for you to know. If you are gifted something and it's just gifted to you, it's not gifted to you and your spouse, that is also separate property. And that's something for you to know. A common example of income earned during a marriage that can be separate property is something like this. If you have like a rental property, and you owned it before marriage, and you're getting rental income during the marriage, that income is separate property. Now, you can turn separate property into community, and there are other ways to do that, but that's for a discussion a different day. So we talked about the purpose, which is protecting assets, clarifying rights, and preserving separate property in some instances. The timing on a prenup, it's obviously done before marriage. This is really, really important. So I hope that you take this away, if nothing else, on prenups. You are not going to have a successful, valid prenup if you negotiate it and sign it like the day before a marriage in most instances. Prenups, best practice should be completely executed 60 days before a marriage. 30 days is kind of what I think of as the bare minimum. If you run into a timing issue like that, you probably want to consider doing a postnuptial agreement, and your attorney can talk to you about that. Because the first thing I told you was an agreement's only good if it's valid, okay? Common provisions in a prenup include asset and debt division, how wages are going to be treated, how retirement accounts are going to be treated, spousal maintenance, if that's going to be an issue, addressing that or waiving it, treatment of, like I said, future earnings and business interests, if anybody owns interests, inheritance rights, and you're also going to want to determine in most prenups whether that agreement is going to survive death and if it's going to alter any surviving spouse rights or not that you would otherwise have under Washington law. So those things are all very important to know about and talk about. There's legal requirements, though, for these agreements agreements to be valid. So the first question really is the agreement fair? It's a two-pronged test. And is it fair is a totally objective thing. If you've ever watched me talk before, I've told you that there's not really anything that counts as fair. Fair is like what you pay if you're going to go on a ferry or the light rail, or it happens at the Puyallup and you go on rides. Take it out of your vocabulary when you're thinking about family law. Because I promise you, what you think is fair is not going to be what your spouse necessarily thinks is fair. So what they mean when they say is the agreement fair, what they really mean under that test is it, does it follow what Washington law would do in dividing the debts and assets? Well, 99% of the time it doesn't, or you wouldn't have an agreement. So strike that. And then you go on to the second part of the test, which is really, I would call the meat and bones of the test for validity of an agreement in Washington state. And you look at a number of factors in figuring this out. There's a key case on this that sets for these factors. You don't have to worry about the case law on it, but that's where this is coming from, just so you know. The first thing is, was it voluntary? Is there any coercion, duress, undue influence? Was someone threatening you, saying you needed to sign this, or saying, I'm gonna do this or take all these things from you if you don't, right? Was it voluntary? Did you do it voluntarily? Another thing is full and fair disclosure. This is so important. I've seen agreements invalidated because the parties didn't fully disclose their debts and assets. The reason behind that is you can't enter into an agreement if you don't know what the other person has, right? So you need to clearly set forth your debts and assets and income, how much you're making, how much you have, what's your separate property, how much debt are you bringing into the marriage? All that needs to be disclosed by both parties. Independent counsel. This is recommended, but it's not required, but it enhances enforceability. It's a question the court would consider if you had an agreement and someone was trying to invalidate it. Did each of you have an attorney to review that agreement? Usually what happens is one attorney drafts it, the other attorney reviews it, and then the agreement is negotiated for. That's another factor. Was the agreement negotiated for? And that fits into kind of a lot of things here. Voluntariness, having someone independently review it, but it's really, really important to know whether it was negotiated. If I just give you an agreement a day before we get married or a week before we get married, say you have to sign it, and the other person's like, okay, that's not negotiated for. So when you have attorneys, there's going to be a question of, oh, I want to make a change to that. Some negotiation showing that it was meaningful negotiation surrounding the agreement. That increases the enforceability, and it's really important. The next question really is substantive fairness at the time of execution. So the agreement shouldn't be unconscionable. It shouldn't, and this is one that is a little bit more of a slippery slope, but the question of fairness as far as what the circumstances are of the parties when it's signed is something that is taken into consideration. And at the time of enforcement, that's another thing that's considered. But really, you need to have, the takeaways are, do it in advance, make sure that it's not, on the eve of the wedding, make sure it's negotiated for, make sure you disclose assets, and make sure that you each have independent counsel. If you do those things, you're going to have a valid agreement. If you don't, probably not, because essentially courts disfavor prenups if they're not able to pass the test, and it could be thrown out. You don't want that. So that's really, really important for you to know. When you think about a prenuptial agreement, it can be difficult to talk to another partner about, because maybe they don't want it or they're going to feel threatened by it. And there's different ways that you can do that as well. Melissa, are there any questions at this point?
You have a question here. This participant is saying that their partner and they did not sign a prenuptial agreement. Now the partner is threatening them and demanding that they sign a separation agreement that requires relinquishing all rights to marital property distribution. Concern, if I'm threatened or coerced into signing this agreement, is it clearly unfair and one-sided? Will the court still enforce it as is? You haven't signed it yet. Don't sign
Yeah,
it.
then don't sign it. Like, there's not really a question. Don't sign it. Yeah, it's not legal advice, but I would tell you, it doesn't sound like you should sign that, just from a common sense perspective.
Well, I mean, and also if you're feeling threatened and if your safety is at risk, then that's a different concern altogether, right?
Then it's not valid. Yeah. But you shouldn't sign it, because then you're going to be dealing with having to prove that later.
Exactly. Then you have to prove it.
So, I mean, I don't know why you would sign it.
Yeah.
I wouldn't do that. Yeah. It doesn't sound like that's a good idea.
Another question, what defines separation in a marriage? Clarification, this person moved to another city for work 2.5 years ago, still married, but living separately in terms of income and expenses, but paying, mortgage where the spouse lives. What defines?
Yeah, data separation is something that often gets disputed and talked about, and you'll have to agree on one for purposes of like, if you're doing a separation contract, which is not a prenup. But data separation can be when somebody moves out. But if somebody moves out, I'll tell you this, spouses live in different cities all the time. Somebody goes there for work. It doesn't mean you're separated. Spouses might live in the same house and still be separated. It's not necessarily a geographic thing. But if someone moves out and says, I'm leaving you and I'm moving down the street or whatever, or if someone says, I'm moving down to the basement and I'm leaving in the same room as you and I'm moving downstairs and we're getting divorced, that's still data separation. If somebody moves to another city and you're still married, but you never had a conversation saying, hey, relationship is over, then data separation isn't that. So I hope that that helps.
Yes, perfect.
Yeah.
Another question on property acquired before marriage. Would that be considered personal property or would it be community property if it was acquired before marriage? Can you talk a little
Personal
bit about
property, like here's an example, if you owned a sofa before marriage and you brought that sofa into the house you were going to live in together, you guys use that sofa during the marriage, it's still separate property. It's probably not worth anything because it's a sofa, and personal property is not worth a lot in a divorce unless it can be specifically appraised. Otherwise, you get garage sale value. But specifically personal property, no. The most common things to think about here really are this. Here's the rules for property, and this might help you. The character of property, you might hear that in a divorce. Character is separate or community, okay? So the character of property is established when the asset is acquired. So when you acquire something, when you acquire that sofa or you buy a car or a house, when you did it, if you did it before marriage and potentially before a committed intimate relationship, which is another thing, but when you did it establishes whether it is separate or community. There are ways you can change the character of that property, but it requires one of two things. One is commingling. If you put separate property money that you got from an inheritance in a community account, and then enough money comes in and out of there that you have what we would call commingled that money beyond recognition. So there's so much money coming in and out, you can't tell anymore that that money is still there. That money could be commingled beyond recognition and is no longer separate. But the most common and the clearest way to change the character of property is a doctrine called transmutation. So transmutation requires an intentional writing, actually saying, I'm changing this house to become community. It might be a refinance, and it requires a showing of intent, not just that you refinanced to get a better interest rate, that you intended to make that home community. So changing separate property to community property requires transmutation, which is a writing plus intent to change it to community or commingling beyond recognition. But otherwise, the character of the property is established at the time it's acquired. So that's a lot of information.
Can you talk about it more specifically as it pertains to a house, a home?
It's just what I told you.
Yeah, same, right?
Bought the house, if let's say you bought the house 5 years before you got married and you lived together during the marriage, it's still a separate property house unless you refinanced it and intended to give it to the community. If there was large amounts and then the other person, there might have been some community money going towards the mortgage, but that person got the benefit of living there and they would have had to pay rent elsewhere. So that's one way to think about it. So, okay. I'm going to talk.
There's 2 other questions, but go ahead, go into that.
I'll talk about postnuptial and then I'll come back. Postnuptial is not that different, but it's important to touch on. So we talked about the test for agreements. It's the same for postnuptial agreements, absent the closeness in time to the wedding because you're already married. So you enter into a postnuptial agreement after marriage, okay? So it's often used, when would you do this? You would do it if you are facing a major financial change in a situation, or maybe one party has inherited a bunch of money, or someone has started a business, or maybe the parties are going through a rough time and they want to take the issue of what happens if we get divorced off the table, and they want to decide what that's going to look like. So it's not an issue that someone can talk about later, but it's really used as a tool to define the rights and liabilities of the parties after marriage. And it will be binding if you get divorced. So postnuptial agreements can be very, very, very effective and efficient way to deal with finances. Sometimes I will do an agreement, and sometimes there's agreements that are they're postnuptial, but they're also separation contracts. Like maybe a party is separating for a period of time, like a trial separation. It's very common during that time for certain people to want a separation contract that says, we have separated on this date, our community has ended, and this is how we're going to handle things during the interim. We're not divorced, nobody's filing for divorce right now, but we're operating under this separation contract. This is how we're handling things. And then if you get divorced, it defines the rights and liabilities if you're divorced. So that's common. That's kind of a separation contract type postnuptial. But a postnuptial can be same as a prenuptial, just to define what happens if we get divorced. It doesn't have to deal with the separation period. And they're also often commonly used if you're too close to the wedding and you just want to do a prenup, but you didn't really have time. So you can work it all out and then execute it after the wedding without the pressure of that closeness in time. So that's really, really important. It's a great tool. It needs to meet the same requirements as prenups. Everybody has to disclose debts and assets. There's actually a higher level of scrutiny on upholding a postnuptial because there's a fiduciary duty between spouses. You guys owe each other a duty of that anyway. So you really want to make sure as well that it's very clear. And I would say in a postnuptial, if it's even possible, I always say both parties should have counsel, but in a postnuptial, it's even more important that you each have independent counsel because sometimes postnuptials have been invalidated due to potential undue influence and making somebody feel like it's not voluntary. Like, hey, if you don't sign this, I'm gonna kick you out or whatever. So both parties having attorneys is even more important. Again, common provisions, assets, spousal maintenance adjustments, business ownership clarifications, and debt allocation. If somebody owns a bunch of student loans that they got during the marriage, it might be a time to allocate, how that's going to be dealt with. So anyway, that is a little bit about postnuptial agreements. I know you had more questions, so I can take some of those.
Yeah, the question is to what extent can agreement control settlement of the marital assets with judges having leeway in determining equitable distribution? But if there's agreement, there's agreement. Does it have to be? I don't know. They're just asking to what extent, parties agreeing controls the settlement versus judges or, the court
I
making
don't
a.
understand the question.
Yeah, I think the question is um if there's an agreement, then there's an agreement, right? There doesn't have to be a judge weighing in about equitable distribution. Can parties agree on maybe a
In
skewed
a divorce or
in a divorce,
yeah.
settlement of marital assets? Yeah.
Yeah, if you want to give somebody all the property, go ahead. The
Yeah.
court doesn't care. The only thing the court cares about and has the final say on, if you're getting divorced and you're like, this other person's getting everything, the court's not going to go through it and be like, why? They don't
Yeah.
care. If you're
Yeah.
going to do that, fine. What they care about and what you're not guaranteed to get signed off on in a divorce is a parenting plan or an order for child support. A child support order, the state has an interest in protecting the children, and there can be an interest given state resources as well. So a child support order that has a deviation to no child support transfer payment or nobody paying expenses is going to get really strict scrutiny from the court. So is a parenting plan. So a parenting plan and child support order are strictly reviewed. But if you have a settlement and you want to agree on a settlement, like that's fine, but you better make sure that it is appropriately drafted and contracted for. Otherwise, you could have somebody coming back and saying, oh, everything wasn't disclosed, or oh, this or that, or oh, somebody's trying to vacate the divorce because you didn't do it right. So you can agree to what you want, but that doesn't change the fact that you should still be really careful with it. So I hope that helps. I think that was the question. I'm not sure.
Yeah, I think it was a question too. Another question, how long after a divorce is finalized could you contest the agreement regarding division of assets if later you discover there were hidden assets or if you feel like it was coercive?
Well, if you just, okay. I'm just going to tell you this now, and maybe you don't want to hear this, but if your divorce is final and you got a final divorce order, there is a mechanism called a motion to vacate, a CR60 motion, that you could bring within a year of basically discovering whatever it is that you're saying you're discovering. But it's a pretty high bar and it's pretty difficult. So you shouldn't ever think that, oh, if someone's hiding something, I'm going to find it later and I'm going to invalidate my divorce. No, typically also too, in meaningful settlement agreements, there's going to be a provision that's going to say, if either party fails to disclose an asset, above a certain value, usually it's $1,500 or $2,500, whatever it might be, then that asset will be divided disproportionately, 75%, for example, to the party who it was hidden from and 25% to the other party. So that's used to encourage disclosure. But if you are going to discover something later, usually a provision like that will control. It's not going to invalidate your entire divorce. So if you think there's hidden assets, it doesn't necessarily mean it's going to invalidate your divorce. And you still, really need to look at the closeness in time to when you discovered that, or should have discovered that, or could have discovered that, because it's not like an open-ended time period. But it's also difficult to get something vacated. Finality of divorces and litigation is a real thing. So don't ever enter into something if you're not sure. So I hope
Thank you.
that's helpful. I'll take one or two more.
Yeah. Is it generally recommended to get a prenuptial or a postnuptial, or which is, preferred, even if there is not a lot of property involved, like under 1 million, if there's less property
Yeah,
involved, it's still,
I've seen people fight about nothing and spend $100,000 on a divorce, or yeah. I
yeah.
mean, I meant what I said earlier. So if you take nothing else away, take this away. A prenup is not necessarily either about what you have right now. It's about what you're going to have, and it's about eliminating the ambiguity surrounding the division of debts and assets. Here's the thing, right? So I told you already that we're not a 50-50 state. I think I said that. If I didn't, I should have. Community property is not necessarily divided 50-50 in Washington, okay? It's divided along just and equitable, fair lines, right? So the things the court looks at, or a settlement is cast in the image of when you're talking about dividing debts and assets, is how long you've been married and what's the financial circumstances of the parties. And does somebody have a bunch of separate property, right? That may or may not matter. But it's important for you to know that you could have a situation where one party may think they should get 60 or 70% of the community property. The other party might think they should get 50, and so maybe where do you land? Somewhere in between, but it can take a lot to negotiate that. And you might not be talking about a lot of money, but if you think about it, a family law trial, if someone thinks, oh, it's not going to cost me that much, if there's $100,000 on the table that you're fighting about, that's still worth it for a lot of people to go to trial over. And you can spend a lot more than that to get there. The idea of an agreement really is not just for people that have high net worths. It's for people to, like I said earlier, understand how income and money and wages are going to be treated, right? Like if you don't have an agreement, your 401k is just as much the other person's as it is yours. If you do have an agreement, you can decide how you want that to look. If you are the breadwinner, or you're the spouse who doesn't make as much, and you're married for a certain period of time, you might be wondering if you're going to get spousal maintenance, and that can be something that's really worth it for a lot of people to fight about too. So yes, I think in general, more and more smart people get prenups, and doesn't mean your marriage is going to fail. I really liken it to insurance. Like I don't drive around with like the highest amount of liability of insurance on my car because I'm planning on slamming into someone and hurting them. I do it so if it happens, I know that I'm protected and it doesn't financially decimate me, but hopefully it never happens. So that's kind of how you think about it. So I hope that helps.
Mhm.
Okay, one more.
Can you say how long does the prenup process take if there are not a ton of negotiations happening? What is kind of the
It
general
depends on the attorneys that you use, number one. I can't tell you how many times I've drafted an agreement and the other party, like, they don't have time to review it. They've got something going on. It can drag on for months, or it can be really fast if both parties are aligned and they have attorneys that are available and ready to help you. So the way I would look at it is understanding what the process is. Generally like this. Attorney and client meet. They discuss what's recommended. Attorney will typically draft an agreement, review it with the client. Client might have, input, changes, edits, things like that. So you'll come up then with a final agreement. Then it goes to the other party and their attorney. That party looks at it. They will review it together on their own. The attorney might come back to the other attorney with edits, and there might be several rounds of that, or there might not be. There might just be one or two, right? But how fast all of that happens is really depends. I've had prenups finalized really quickly in a couple of weeks. I've had some take like a year. So there's just not a real hard and fast rule on it. So that's why the sooner that you start is the better. I had somebody who we started last year. They're getting married, I think, in August. And I mean, it took a while. There was a lot going on there, but it took a while. I've had other people who don't have a lot, and it still takes a lot because somebody's not quick to respond or whatever. So allow for enough time. And if you're running out of time, do it as a postnuptial, but still start that negotiation early so you get it done. So I hope that helps.
Great. Thanks.
Okay. I will talk about, just to make sure that we have time to really discuss this, I want to talk about cohabitation agreements, and then I want to talk about kind of some best practices for agreements. So cohabitation agreements, like, why would you need that? First of all, here's a secret. I don't know if everybody knows. If you're watching this webinar, you might know. I don't know. But living together in Washington confers different rights, or can potentially confer different rights than it does in other states. Living together in Washington can mean that what we call community-like property or quasi-community property attaches, which means you're not married, but it's still community-like property. That means if you start living with someone and you're in a marriage-like relationship, which is really a committed, intimate relationship, you live together, you hold each other out in the community as partners, everybody knows your partners. You pool resources, maybe one person you each pay towards the rent, or somebody pays towards expenses, or whatever. You pool resources like, people do when they're together. The purpose of the relationship is for an actual committed, intimate relationship, not just a friendship or roommates. And the relationship cohabitation is continuous, and the relationship is exclusive for the most part. And that's what's decided. You could have a committed, intimate relationship. So what that means is you could live together. I had a case in Snohomish County that went to trial. It's been a while now, but it was a great example because they lived together for 15 years, and my client really didn't know that this was a thing. So when they broke up, she thought, okay, hey, I bought this house while we were together. Most things were in my name, and he's not getting anything. And then he files for a committed, intimate relationship, and she's like, oh, he has an interest in my house now and my retirement that I've been earning over all these years. And it was a real issue. And that was a good example of people having no idea, and the woman just felt really, really blindsided. And she's like, well, I would have made him sign an agreement years ago if I'd known, right? But how would you know? It's even more common now. I think, especially in the tech industry, where people start living together and somebody is granted a bunch of restricted stock units or gets a really large bonus and then goes out and buy a house. And they're granted that while they're already living together. So there's a presumption, if there is a committed, intimate relationship, that could be community-like money. And then the house is bought with that money that they earned while they were together. And that house has a community-like interest, and they never thought that. So a lot of the times in cohabitation agreements, people really like to do what I call a name on title agreement. That's what's mine is mine, what's yours is yours. The name on the title of something defines the character, and that's not the law necessarily in Washington. So that's a common thing that helps people keep things simple, and that's something to consider. But yeah, cohabitation agreements, it's to define, the purpose of it is to define the rights of unmarried partners living together, and to clarify rights during and then also after cohabitation, if cohabitation ends. The legal context in Washington really is that we don't recognize common law marriages in Washington, but we do recognize committed, intimate relationships. And a lot of people think, well, there's no common law marriage, nothing happens till we get married. And that's not true. I had a case a couple years ago as well. It was a trial case where they were married for like 9 months. They weren't married that long at all, but they lived together for 12 years beforehand. So instead of looking at like a less than 1 year community property period, we were really looking at like a 12, 13 year period. So that was a totally different issue. And then the question was, when does that committed, intimate relationship start? Did it start the day they moved in together? Probably not. Did it start, and then it becomes more about the benchmarks of the relationship and when it became a committed, intimate relationship. So that's really important for you to know. Importance of the agreements. You want to really avoid the uncertainty of the equitable distribution under the committed, intimate relationship doctrine. Just like I told you in divorces, it's just an equitable division. It could go either way, depending on the resources and the length of the relationship. Same for committed, intimate relationships. If someone proves a committed, intimate relationship, the division of the property, it could be more to the person who made less. I mean, you don't know. So having an agreement is going to define what could happen, or if anything's going to happen, any division. You get to address property rights, household obligations, all of those things. It's actually a really good thing to do if you're going to be with someone not just planning on breaking up, but so you can have those tough conversations about, how are we going to handle finances, right? Are we going to have a joint account that just pays household bills? Are we going to each pay separately? What are we going to do? And talking about those things can be very, very important. Enforceability, the enforceability of these agreements is governed by contract law principles. So offer, acceptance, and consideration, which is different necessarily than a prenup. But basically, courts will enforce it if the contract is clear, voluntary, it's not totally crazy and unconscionable, and there is an actual offer, acceptance, and there's consideration. So it's important for you to understand that you need to have validity in any agreement that you have. The best practices, I'll go over those briefly, is use of independent counsel. Both parties have their own attorneys. Those attorneys don't work in the same office. They don't work for the same firm. They're independent, okay? And they're able to give you independent, objective advice. Second is full financial disclosure with documentation. You need to disclose your assets, and one party may want to review them. The other party may want to review them. You have to be able to prove what you're disclosing if someone wants to see that. Or at least give them the meaningful opportunity to do so, even if they choose not to. Adequate time for review before signing. Even if you're doing not necessarily a prenup, you don't want to feel rushed to sign it. You want to have time to review and get that advice from your attorney and ask all the questions. Consider avoiding overly broad or punitive provisions. Like some people will want to put like an infidelity clause. I always discourage that. Number one, courts don't like it. And number two, then you're going to have a relationship where someone's trying to catch up on the other person, and it just creates a situation that's really unhealthy and hard to enforce. That's seen as a punitive provision. You also want to avoid, like I said, overly broad provisions. I can't tell you how many agreements I've seen where I'm like, this doesn't tell me anything. So then you think you have this agreement that is great and you're going to get divorced and it's going to protect you, but it's not super clear. So then we still have things to figure out. So you want to make sure that that agreement is very clear and things are not overly broad. That's very, very important. I think it's also good to consider doing periodic review and updates, especially of postnuptials, like if circumstances change. That's another thing. And here's the last thing I will say. If you do a prenup or a postnup, it's potentially going to alter your inheritance rights, and you need an estate plan, and you need your estate plan to not be in conflict with your agreement. You can have your prenup saying one thing and your estate plan says the other thing, and you just created a big mess. So it's very smart to determine whether the agreement is going to survive death or not. And if you're going to have principles in there that are going to alter rights, you want to make sure that you then have the parties update their estate agreements, and it's noted in the agreement that the parties are going to do that. And if they've already done it, it's attached as an exhibit to the agreement. If it's not, it's said they're going to do it within 6 months. And if they don't, this controls. So it's really important to know all these things, which is why it's important to have an attorney and not download something from ChatGPT or LegalZoom or something like that. So I hope that that's helpful. I can take a few more questions before we wrap up.
Are there any unique hazards or considerations related to seniors?
Yeah, I think, well, I mean, yeah, I think so. I mean, I think, I don't know. No, I wouldn't say necessarily, I would say this, okay. People at any age, when you're doing an agreement, you're going to want to take into consideration how old people are. So if people are retirement age, just like in divorce, there are what you're looking at, or if it's been a long-term marriage or whatever, or if it's a short-term marriage, but it's a second marriage or a later in life marriage, you want to look at what that looks like. Sometimes people won't get married later in life. Maybe a partner passed away or they got divorced because they don't want to not be able to get like a deceased partner's social security or something like that. So sometimes if you're entering into an agreement and it's later in life, there's considerations that you want to, you know, factor in. Just like in a divorce, like I said, you want to look at, you know, basically what the social security situation is, what the life expectancy of people is. So sometimes those things can factor into play, but I really would say that that's true. You know, for any stage in life people are at. Like if someone's not working because they're staying home with kids, they're probably younger, but they're staying home with kids. So that's going to need to be addressed as well, that this is the intent of the parties. This is what the spousal maintenance might look like because this person is sacrificing this. If it's later in life, you're going to say both spouses aren't working, and you're going to look at what the cash flow is, you know, for people that are retired. So a number of things come into play. So I hope that helps.
Okay, thanks. One other question here, less related to the agreements, but just around separation. Does the marriage have to, it's kind of a jurisdiction situation. Does the marriage need to have taken place in the state of Washington for asset division to be happening in Washington, or I guess divorce and, you know,
Say that again. Say that again.
Does the marriage need to have taken place in the state of Washington?
No. It's where you get divorced. I mean, we have people getting divorced here. They got married in India or, you know, Australia or whatever, or Kentucky. It really doesn't matter. It's where you are getting divorced that controls. If the parties are both living here, then you can get divorced in Washington. So,
Okay.
yeah.
Okay, I think we're good on questions right now.
Yeah, good. All right. Well, then I think we're going to wrap up. So again, just to recap for you, prenuptial agreements, postnuptial agreements, cohabitation agreements, 3 types of agreements. Postnuptial agreements can also function as separation contracts, or they can just be a straight postnuptial. So different kinds of things to consider there. You want to have an agreement that's valid. That's very, very important. You want to consult with somebody about your individual situation to determine what should I even put in this agreement? Like what's in my best interest, right? And what's the other party likely to agree to? I like to tell people when I talk to them, hey, it's great that you want to do that, but the other side is not going to agree to that. It's probably going to look more like this, right? Agreements are all about compromise and coming up with something that really works for everybody. So I really hope that that's helpful. Thanks for tuning in, and we'll see you next time. Take care.
Thanks, everyone. I'm just going to leave the contact slide up here for just a moment. Please reach out if you'd like to schedule a consultation with Dellino Family Law Group. If anyone has questions or would like to consult about counseling services, feel free to reach out to me. We do webinars. Michelle does webinars every month. There's a foundations law Foundations of Family Law series that she does every month. And then we do a topic specific webinar each month as well. So stay tuned. We'll have more webinars coming up soon. And please reach out if you have any questions or would like to consult. Thanks so much. Take care.